All right, let's go ahead and get started. Good morning, everyone, and welcome to the South Carolina Solar Council September webinar concerning the Solar Consumer Protection Regulations. I am Roxanne Rich, the chair of the South Carolina Solar Council Board, and with me today is Gretchen Poole of the Office of Regulatory Staff and Carrie Liebarker of the South Carolina Department of Consumer Affairs. Please briefly look to the top left of your screen and you'll see that we have our fall meeting coming up. It's going to be on October 8th from 10 to 2 p.m. We hope you can all join us. We are currently monitoring the current events of the world to see if we're going to be in person or virtual, but we are going to discuss that once again at our September meeting, and we'll get back to you as soon as possible with registration and an agenda. Without further ado, I'm going to pass it off to Gretchen to begin her presentation. Bear with us, I'm going to be working the PowerPoint and Gretchen's going to be presenting, so you're going to hear a lot of next slide, please. All right, over to you, Gretchen.
Thank you so much. So we are here today to talk about the new South Carolina Consumer Protection Regulations. And I'm going to talk from an ORS perspective, and then Carrie's going to talk about the Department of Consumer Affairs requirements and some of their forms. So with that, the next slide, please. So the ORS was created in 2004, and we represent consumers of all of the investor-owned utilities, and we are looking out for the consumer, the impact of things to the consumer and the utilities' continued investment to provide them reliable and quality service. Next slide. So our responsibilities when it comes to solar is really to do with the leasing piece of things. We are required, or I'm sorry, lessors are required to send in an application and obtain a certificate of fit, willing, and able from the ORS prior to marketing their services or leasing any type of renewable electric generation in South Carolina. It's a process that typically it takes about a month for us to review an application. I believe it's 60 or 90 days to get those turned around. And we currently have 3 applications in process at the moment. Next slide, please. So the General Assembly earlier this year passed some new consumer protection regulations, and these became effective on May the 28th. And they require lessors to provide some additional information and disclosures to customers. And it also created a formal complaint process for customers to resolve any issues they may have with the leasing companies. So next slide. So with everything that's new, the lease agreements have to include that certificate number that's issued by us here at ORS. And it has to be clearly on that lease agreement. And that lease agreement must also include the State Energy Office's solar consumer information, which you find there, and then the ORS telephone number and email address for any complaints. That has to be clearly seen in the lease agreement. And the process here in our office, when we receive a complaint, we will notice the company of any violations and give them a chance to respond. And then we will investigate and issue a decision, and they can request a review of the decision and appeal if necessary. So it's just a formal complaint process. And on the next slide, what most people are curious about is what can happen for noncompliance. So the first thing is that we could void the lease agreement. We could assess monetary fines to the leasing company, and we could also suspend the lessor's operations in South Carolina. So it's important that all these things get put into the lease agreement. Some other things, sellers must give consumers a pamphlet that tell them their rights and responsibilities. And then their contract must include a standard disclosure. And that's to help them compare different offers and the terms of the contract. And then they must be given a copy of the contract. And that contract you can see has to have all their fees, their savings that have been communicated, warranty information, installation dates, and the like. And to protect our elderly customers that are 70 years or older, have to be provided a copy of the lease agreement and at least 3 days to review it before they sign it. And then all customers have a right to rescind or cancel the agreement. This is another big piece until midnight on the 10th calendar day from when they sign that lease. So in the past, people have just kind of put their own right to rescind in there. But that is something very important and very different. And then some resources. Carrie's going to talk to you, I think, more from the Department of Consumer Affairs side, but the South Carolina Energy Office is always present as well. And we're happy to help here at ORS as well with any questions or guidance that you need with the leasing process. And if you have any questions, that's my contact information. Feel free to give me a call, send me an email. If I don't know the answer, I will certainly try to find the answer for you. Thank you.
Great. So good morning, everyone. I am Carrie Gruby-Liebarker, and I get to serve as the administrator and consumer advocate for the South Carolina Department of Consumer Affairs. So I'm going to talk to you about our regulation, give you a little bit of background on DCA, talk about the complaints we had received and other items that kind of served as a foundation for the regulation, the process we went through for drafting, and then, of course, the content and the forms that Gretchen mentioned. Next slide, please. Which probably goes 2 slides because I think I just did the overview too. Oh, no, good disclaimer, which you're fine with where you are too. Just want to make sure that everybody knows the presentation is not meant to serve as a substitute for reading the actual laws or the actual regulation or otherwise seeking legal counsel from our office for guidance and interpretations, just trying to give an overview for it. Thank you. And that's our roadmap that we just covered. And now here's the DCA overview. So the Department of Consumer Affairs was created in 1975. We have 45 full-time employees located in one office at Greystone Boulevard, right by the zoo here in Columbia. And we have over 120 statutes to administer and enforce, plus the accompanying regulations. And that includes Title 37, which is the Consumer Protection Code that generally covers rent-to-own, leases, consumer credit sales, and consumer loans. So our mission is to protect consumers from inequities in the marketplace through advocacy, mediation, enforcement, and education. And we have a policy-making body that is our Commission on Consumer Affairs. 4 members are appointed by the governor, 4 by the General Assembly, and the Secretary of State serves ex officio. They appoint the administrator, myself, to oversee the day-to-day operations of the agency. We also have a council of advisors, and they are 16 members made up of industries that we regulate, and all of them are appointed by the governor. They're not policymaking, they solely are just an advisory board to give us that boots on the ground industry perspective on areas, especially education, legislation, and some enforcement issues. And then we have 6 divisions. I'm not going to get too much into them because of the time constraint, and there really is a lot of meat to the regulation and hopefully some questions and that y'all may have that I can answer to at the conclusion. But just consumer services and education, that's our complaints division. So most people know us for that. So a consumer, and when I say consumer, because I've noticed there's kind of a different perspective in the utility arena versus outside of that. We're looking at folks who are using goods or services for personal, family, or household services. So that's our definition of consumer. So if a consumer has a complaint against a business, they can file it with us. If it's regulated by, if the business or the issue is regulated by another state or federal agency, we'll kick it to them. If it's regulated by us, then we'll go over to the legal division with that complaint to see if any of our laws have been violated. If it's not regulated by anyone, which about 7 or 8 out of 10 times is what occurs, then we'll engage in voluntary mediation. And I believe we got about $500,000 through that process in the last fiscal year. Then we have our administration division. They keep our office running with HR and IT and all that good stuff. Advocacy, which a lot of you may know us for. And so that's our intervention into both insurance rate filings as well as utility rate filing. So we had that ability from about, I think it was 1978 until 2004. And then it was restored to us in a more limited capacity than what it was previously back in 2018. So we have intervened in, I think, 4 general rate making cases and 2 avoided cost cases so far since that's occurred. And we also provide rulemaking comments to state and federal agencies who are providing rules that cover consumer goods, products, or services. And privacy has been a big ticket item lately. Telemarketing and robocalls have been as well. That's what a lot of our comments have focused on. Our legal division is our largest division. So with over 120 statutes under our jurisdiction, that's not too surprising. Most of them are consumer credit related. There's a consumer credit contract associated with it, then our office regulates that contract or that particular industry. And so it runs from mortgage brokers, pawnbrokers, physical fitness facilities, credit counselors, pre-need funeral contracts. And then we also get some random ones thrown in there because of folks' different perspective of consumers and what that means. And so we regulate athlete agents. So all that name, image, and likeness stuff that you may have heard of in the headlines is something we're dealing with as well right now too. So we bring our own actions in state, federal, and local courts. We have investigators that go out and do compliance reviews to make sure folks are complying with the law. And as I mentioned earlier, we have complaint analysts that deal with those complaints that have businesses or issues under our jurisdiction. And then we have licensing analysts because we get about 27,000 filings annually. Public information, that is a very small division, but we say everybody is a member of our public information division. So education is a core component of our mission. We want to make sure consumers and businesses alike are aware of their rights and responsibilities under the law. So we do presentations such as this, press releases, publications. We're active in social media, any kind of channel we can use to get the word out, we try and use. And then our identity theft unit is our newest unit. It's been around since 2013. And their mission is to try and prevent folks from becoming identity theft victims through education. And then if someone is an identity theft victim, we attempt to mitigate that event for them. They also take scam calls and get information on those because normally someone's trying to get their personal information or their money. So that's a little bit about DCA. So we'll go ahead and roll into the solar regs. Oh, sorry, I forgot I had animation in this. And there is animation throughout. Okay, so as Gretchen mentioned, Act 62 that came about a couple years ago required our office to develop consumer protection regulations regarding the sale or lease of renewable energy generation facilities, and then also make clear that Title 37 as a whole would apply to sellers. So we went about trying to draft the regulation. Go ahead to the next slide. By first looking at the consumer complaints that we had received. So from January 2014 to January 2020, we had 198 complaints that identified about 229 different issues. And through our mitigation of those complaints, we were able to get $700,000 in consumer credits, refunds, and adjustments for consumers. And when we started looking at the complaints, we found some trends that we thought would be helpful to address via the regulation. And so the most common complaint was misrepresentation, mainly about the savings that consumers would receive once the solar was in place. And then the second most complained about issue was that businesses are promising incentives. Go ahead and press, yep, thank you. Promising incentives and rebates to help with the cost or pay for the cost of installation. So essentially those incentives or rebates did not come to fruition for those folks. The third most complained about trend was that consumers were not receiving their paperwork. When folks file a complaint with our office, the first thing we ask for is any supporting documentation that would include materials that were received during the marketing process or their contract, and they oftentimes could not produce it, and that was part of their complaint as well. And then there were a bunch of them where they didn't provide the equipment that was specified in the contract. So when we looked at these complaints, we found that there's a bunch of moving parts in the solar process, and I'm saying solar, the regulation is for all renewable energy generation facilities. It just so happens that solar is the most popular one of those in the state right now, but please by no means interpret that as meaning this is solely for the solar industry. And we'll talk about that when we get to the definitions as well. But we were looking at it, and we saw that there's often a salesman and a lead generator, a finance company, the solar company itself, and an install company. And then that consumers didn't really understand how many players were involved and how they all related to one another. And then we also realized that there were several companies involved in the process that were not aware of applicable laws that had been in place today that they should have already been complying with, that they weren't. And so just to give you a couple of those laws that we looked at, because we wanted to make sure that the regulation was not going to conflict, but would rather support or complement these particular laws. So on the federal side, you have the Federal Trade Commission Act, the Consumer Leasing Act, or Reg M, the Truth in Lending Act, and the Unfair Deceptive Practices Act. And on the state side, as I mentioned, the Consumer Protection Code deals with consumer credit transactions. So that includes credit sales, that includes home solicitation sales, consumer leases, consumer loans, advertising, credit grantor maximum rate. Credit grantors, if you have over $150,000 in volume of credit transactions, which includes leases, you're supposed to be making a filing with our office. Maximum rate, folks who are charging over 18% in a credit transaction. Truth in lending, unconscionability, the Unfair Trade Practices Act comes to mind. There's telemarketing laws that come to mind too. So there were so many laws out there that we were looking at, again, to try and make sure we don't conflict with those through the reg. So with the reg process, we went ahead and did a notice of drafting in December of 2019. We held a joint workshop with the Office of Regulatory Staff and interested parties on January 8th, 2020. That was a great workshop. We went through different buckets that we had found by looking at other states' laws, and then again, those complaints, and trying to figure out the different kind of items that would be content in the regulation and get feedback on those. I think there were about 11 potential areas that we discussed at that time. And then we published our first proposed regulation in the February 2020 State Register. We got about 18 comments, which is a lot of comments for us in a regulations process. I think we normally average one, maybe. So it was great to get everybody's feedback from all the different areas that touch solar, including consumer representatives, utilities, and of course, solar companies. And then we changed some of the content based on those comments and ended up publishing a second proposed regulation in September of 2020. And that is document 4994. And so that's what went through the legislative review process. On the House side, we were requested to withdraw and resubmit it due to some of the concerns by the industry. So through that process of the withdraw and resubmit, we clarified the definition of lead generator to make a clear distinction between the seller and the marketer. We adjusted the presentation of the disclosures, changed some words like rescission to cancel, and had to change some of the disclosures based on other changes that were made throughout the document. We adjusted parties that we should consult on, adding the conservation groups, and clarified language for the contract, removed the rejection by an electric provider as one of the contingencies for cancellation, and added the failure for the local building authority to grant the permit. And so then I'm going to go through the details of what the final regulation looked like momentarily. Which the final one was published May 28th. Okay. So as I mentioned, this regulation applies to renewable energy facilities. And that means any facility that is utilizing electrical energy, renewable generation resources, such as, and then there's the laundry list that we have that includes solar, and includes wind, and includes tidal and wave. Again, it's an all-inclusive reg, even though I may say solar repeatedly, again, because of my audience and because of what we're seeing as far as what's being marketed to consumers. So there's two main components to our regulation, the marketing side of it and the standard agreement side of it. So as far as the marketing goes, the regulation requires that a written pamphlet be provided to consumers by any person who is marketing the renewable energy. That pamphlet is supposed to detail some consumer rights and responsibilities. And through that process of creating the pamphlet, we were supposed to get with particular groups that were delineated in the regulation that included Office of Regulatory Staff, utilities, consumer groups, solar groups, and get that input, kind of put it into a draft document, and then solicit comments on that, edit it as needed, and then send out as the final document that was supposed to be used. And so who must provide the pamphlet? Any person, very broad, making a solicitation for renewable energy facilities. And specifically, the regulation says that the pamphlet shall be given to a consumer at the time of any renewable energy facility solicitation, and each person engaged in the renewable energy facility solicitation shall be responsible for reproducing and distributing the pamphlet finally approved and authorized by the department. And so we always tell folks to err on the side of caution. I know this is the 4th solar presentation that I have done on this regulation in the past 3 months. And I keep adding in a little bit more information based on the questions that are coming up. And we had one of these questions the last time we did the presentation of whether or not somebody who has a lead generator or a third-party marketer, when they come into the picture, do they have to provide that pamphlet to the consumer? And so one note that I want to make is that the lead generator didn't do it, you're responsible for that. So erring on the side of caution and making sure that that marketing pamphlet is given to the consumer is important. And then the other part of it too is, are you solely coming in to enter into the contract, or is there still some marketing going on there, some soliciting going on there? And if there is marketing or soliciting going on, then yes, you too do need to certainly provide the pamphlet to the consumer as well. So again, erring on the side of caution is the way to go. It's a 2-sided pamphlet. We'll get into that content momentarily there. So what is a renewable energy facility solicitation? So this is a long definition. It's one of the longest definitions that we see in the regulation itself. And so there's essentially 4 different categories. So it's if somebody is for compensation or gain, or with the expectation of compensation or gain, offering, soliciting, brokering directly or indirectly to arrange, place, or find a renewable energy facility for a consumer in the state. If they are engaging in any activity intended to assist a consumer with obtaining that facility, including lead generation. If they're arranging in whole or in part the sale or lease of a renewable energy facility through the third party through any method, including mail, telephone, internet, or electronic means, or if they represent to the consumer that they can or will provide a renewable energy facility or any of the services described in A through C above. So very broad definitions. If you want to click, I have some animation to go over. So that first one is like a catch-all. The second one seems to apply to the seller, the lead generator. That third one is those third-party marketers or lead generator. And then that fourth one is like a catch-all too, applying to anybody who's touching the marketing or solicitation of that facility. Okay, so once somebody decides they're going to get involved in the marketing or soliciting for one of these items, what do they have to do? Well, if they're a lead generator, they have to notify the consumer that they are not the ones who are providing the facility. And then that they are indeed going to share the consumer's info with others who do in fact offer the facility. Anyone, any person who is marketing or soliciting shall not advertise or market in a false, deceptive, or misleading manner, or they should not market the product if the retailer or lead generator knows or should know that the consumer will not be able to fulfill the terms of the agreement or benefit from the agreement. So written marketing materials have to meet certain requirements. They have to be at least 12-point font, but there are some required disclosures that have to be in at least 14-point font or more, depending on the type font that's used in the agreement. It has to be provided in the same language as oral representations were made, has to contain contact info for the individual who's making the solicitation, and then provide the required disclosures. It's very much an if you say this, then you must provide the written documentation that says what you just said. And that's an area of pricing and of savings and things of that nature. And it very much duplicates into the agreement as well. So if there's any reference to the price of the facility, you have to give the total price the consumer is going to pay, whether the maintenance and repairs are included in the total price, and then their eligibility for tax credits or other incentives. Now, again, as far as tax credits and incentives go, they should not be relayed to the consumer unless it is one generally applicable to the public. Otherwise, it needs to be disclosed in a different manner. You can describe the warranty and the guarantee of energy production. And if there's any estimate of savings, then additional disclosures about how those savings were calculated must be given, as well as statements on contacting your power company and tax professional for additional information. So for the agreements, if the person who is being solicited is 70 years old or older, then they are to be given a written copy of the agreement 3 days prior to that agreement being signed. Then there's also information regarding DCA and ORS as far as who they can contact for complaints that needs to be included. And then there's a right to cancel, which we're going to talk about in a minute too. The total price that's paid in full, whether it's financed or leased, any one-time fees, there's a laundry list that has to be included in that total price. And then the estimated timing of installation and the start of installation start and the completion of the item also have to be included. So this should sound familiar. If you're estimating savings, there should be the material assumptions that you use to calculate disclosed in that contract, and the two statements that we talked about previously about utilities and tax professionals are in there. The disclosures of the warranty and guarantee, again, are maintenance and repairs included. Will the retailer make a fixture filing? Must be disclosed in the contract. How will you protect the consumer's data? And then of course, the consumer is to be given a copy of the fully executed agreement as well. And these are just some highlights. I mean, there really is a lot of detail in the regulation. And again, it's kind of it's a build your own agreement to a certain degree, because if you're not providing certain information, then you don't have to provide all the disclosures that go along with that info. So I just want to talk about that pre-signing waiting period for a second. So this was one of those items that the House asked us to take a look at based on industry concerns. So in the proposed regulation, we had a 3 days for all. So whenever someone would get a contract, they would wait 3 days prior to signing it. But the final regulation has it only applying to those consumers 70 and up. And then, of course, the way that it goes is you give them that written copy of the agreement. You have to present it at least 3 days prior to signing it. If that agreement is amended for any reason, then that 3 days starts over again. Now, the right to cancel. So the home solicitation sales rule, and I think it's the Federal Trade Commission's cooling off rule, required that solar sales agreements that were going, for folks going door to door, they were subject to a 3-day right of rescission. And so this regulation expands that to a 10-day right to cancel without any penalties or fees. But then the regulation also provides contingent cancellations. So there must be approval of the building permit by the local government authority. But if it's denied, the consumer has 7 days to rescind or amend the agreement. Same if the homeowners association does not approve the facility. Once it's rejected, the consumer has 7 days to rescind or amend the agreement. So there's also some ancillary provisions in the regulation, one dealing with due diligence. So, we talked about in the complaints that consumers often didn't understand the relationship between the various parties that were involved in the marketing and the sale of solar. And so we wanted to make sure that retailers do not enter into contracts with third-party servicers who are unlikely to fulfill that contract. So you have to do due diligence when you're picking your contractors. And you need to verify that that third-party servicer understands and is capable of complying with the agreement relating to the install, maintenance, servicing, whatever it is that you're subbing it out to them for. And then construction and installation shall not begin until a local government authority issues that building permit. There's also a record keeping requirement. So folks who are engaged in soliciting or entering into agreements have to maintain certain books and records for at least 3 years. That includes agreements with South Carolina residents, which would also include that standard disclosure that's required by the regulation that we're going to talk about momentarily. Solicitation materials used, again, includes the standard marketing pamphlet, records of contacts with consumers, so the folks that are being solicited, and contact information for any person who received, requested, or contracted for leads or referrals. So we mentioned that the consumer, there's lots of items that they have to receive, but including that written copy of the contract. The law does allow for electronic delivery, but there are 2 parameters that have to be met. First, the consumer has to give prior consent to receiving the items electronically, and then they have to acknowledge receipt of those items. The font and the format requirements are the same. They have to be reasonably similar to what's required if it were to be submitted in paper. And then, of course, it's subject to Uniform Electronic Transactions Act and the Electronic Signatures in Global and National Commerce Act. So remedies for violation of Title 37 or the regulation, the department can issue an administrative order. We can do a cease and desist, ask that property or money received in violation be returned, and the company would pay penalties of up to $5,000 per violation. We can also bring a civil action to prevent folks from using prohibited practices, reform contracts, and rescind contracts. So just to give you an idea of what it means to reform contracts too, sometimes we'll find, if something wasn't properly disclosed, that it has to be redisclosed to the consumer, and the consumer may have the opportunity to cancel it if they so choose. That's just kind of an example from what we've done in the past. And some folks on previous presentations have asked what our enforcement is going to look like in enforcing and administering this particular regulation. And our focus right now is trying to bring folks up to speed to make sure everybody's aware of their rights and responsibilities. To issue guidance, we're likely going to put out some checklists and other items based on some questions we've gotten, like some FAQs and things of that nature, and are still trying to look at what our enforcement might look like. We're probably going to do some advisories, go out and look at folks, see what they're utilizing in their transactions with consumers, and giving input on whether or not we think that that's compliant. So the marketing pamphlet and standard disclosure. Okay, so as I mentioned previously, the regulation required the department to get with certain groups, conservationists, consumers, ORS, utilities, solar folks, and kind of see what everybody thought as far as content for both of these items. So we released a survey on potential buckets or information that we would include in both the marketing handout and the standard disclosure that are required to be given to consumers. We did that in early July, round one, kind of our survey round one. We collected feedback and took that information and released the actual draft documents at the beginning of August, and then again collected feedback and then finalized the document on August 24th. So as far as the marketing pamphlet goes, it was kind of nice because it was nice because the majority of folks were on the same page. We had a lot of comments that were together, so it was kind of a majority rules. If there were multiple folks who were on the same page, that is the item that most likely ended up in this particular marketing brochure. Basically the repeats, if we kept seeing it pop up. But what was difficult for us is we put out a whole bunch of information, and then a lot of folks said, yes, we like that. So we were trying to figure out how we can get this into a succinct, direct pamphlet that consumers can understand. It's in 6th grade reading level. And that there's a lot of white space. We do a lot of consumer publications, and our public information and education department is great with trying to figure out what folks need to know, not everything we want them to know, because I want them to know everything, but there's not a lawyer that can come with this particular brochure. And we're not trying to be too repetitive on things, but are trying to drive some things home. So it really is kind of like an art form there. But we received on round one on the marketing brochure, the marketing pamphlet, 18 comments with some great feedback. And in round two, we got 14 comments. So I really appreciate the input that we've received from everybody. This is definitely one area where that has been the norm, and it makes our job a lot easier. I think there were a couple items that were kind of on the peripheral for this one and the agreements that we'll look at to see if issues arise through complaints or through compliance reviews that we're seeing, that we may want to adjust this after kind of a 6-month to 1 year implementation period. So the different sections that we have, basic terms to know, just kind of gave some definitions for folks. Questions to ask before you sign. By no means is it an exhaustive list, but we just kind of go back to what should be included in marketing materials and in the contract that consumers may want to know upfront before determining if the facility is right for them. We give information about the right to cancel, and then general tips and info that we give in all consumer related transactions to folks, again, based on the scams and the complaint reports that we get here at our department. And then of course, contact information for our office, the Office of Regulatory Staff, and then LLR. I'm going to take one sip real quick. Okay, and then for our standard disclosure, we went through, that same process where we did the bucket kind of survey, did the draft, and then released the final version. For round one, for comments, we got 12, and for round two, we got 10. So again, some really good feedback. We had some attorneys in there too who represent both consumers and attorneys on the industry sides as well that were really helpful. And this was another one where there were a couple items on the peripheral that some folks mentioned One in particular was signing this particular document. So the standard disclosure is to be a part of the contract, right? And so the consumer is signing the contract. So we were trying to not be too duplicitous, and we did receive some feedback from the industry saying they thought that it would be burdensome. So that is definitely one item that we're going to watch, is to see if consumers through their complaints or through our compliance reviews say that they never received this particular document. And then we'll review whether or not that's needed. Gosh, there was something else too. Let's see if I wrote it in my notes that someone mentioned. Oh, a disclaimer that these documents are for residential renewable energy and not industrial or commercial renewable energy. So again, we didn't think that that confusion would arise based on our experience with our other standardized disclosures and items that are utilized in consumer transactions that we have to create. So we'll be watching that as well. So in the standard disclosure, we have different sections. We have consumer information that also has information about the make and model of the particular facility, whether or not the consumer is going to own or lease it, and if they are owning it, how they're paying for it. We have a cost and savings section that talks about the total cost. What should be here is the total cost, not with tax, rebates, incentives, or anything else added in. It's the total cost. You can have all that other kind of stuff in the contract, because if you are saying that someone will qualify for a tax incentive or rebate, you have to give a price for before it's applied and a price after it's applied. And then we have information on other important details, including whether or not there'll be a lien on a home or fixture filing, the kinds of guarantees that are offered. We talk about the waiting period. We talk again about the right to cancel, about the consumer's right to get a copy of the contract. And then again, have the contact information for our office, ORS, LLR, and then contact information for the seller, the installer, and then warranty provider if it's different too. Now, as I mentioned, this does not have to be signed by the consumer, but it does have to be signed by the particular person who completed the document. So both of these items can be found on our website. So our website is consumer.sc.gov. You can go to the Business Resources and Laws page and click on Education and Tools, and it'll be under the Renewable Energy header, and that's where any updates will be as well. We have tried our darndest to get this out to folks through all the different email lists that we've had through the 18-month process of getting this implemented. But if for some reason you did not receive it, you can certainly email us at scdca@scconsumer.gov, and we can email it to you too, but it is readily accessible there on our website. And this just shows you too where you can go, the business resources, you just go to business education and tools. If you want to get the complete regulation to review too, you click over to the last column, I guess we can say, the second item, laws enforced by SCDCA, and that'll take you to our statutes and our regulations page. Go ahead and go to the next slide. And then you just scroll on down, statutes are first, regulations are last, and the sale and marketing of renewable energy generation facilities, that is the first regulation that is listed. So that is the complete regulation too. Again, when you review it, you're going to see that a lot of what's in the marketing, if you're saying certain items have to have supportive disclosures with them, are the same that are in the agreements. We're just trying to make sure the consumer has the full picture of the transaction, so they are getting the right facility that meets their needs as far as generation, as well as their needs as far as their pocketbook. So you can also connect with us on Facebook, Twitter, YouTube. As I mentioned, education is key, so we try and get on all of the traditional and non-traditional media. And then I'd be happy to answer any questions that you may have.
Thank you, Carrie and Gretchen. If anyone has any sort of questions, you can feel free to unmute yourself. We'll try to go one at a time, or you can always type them into the chat for us. But in the meantime, people are kind of brainstorming. I did want to ask Carrie, what are some of the cusp topics that you were referring to when it comes to the marketing handout? What were some of the things that we may see in the next 6 months to a year if we see any issues?
So the marketing would be related on the complaint side of things. So if we start seeing a certain complaint that comes up on a particular issue that maybe consumers didn't fully understand, like we don't talk about We don't get into too much detail on the right to cancel. Some folks were telling us that they would like us to get more detailed on that information. But again, the marketing pamphlet is just supposed to kind of be that highlights, bringing out the most important information, and then all the other additional items would kind of supplement that. So that was one item that I remember off the top of my head. But I do think that it'll be governed by what kind of complaints that we get to see what kind of education the consumers need at that point.
Gotcha. We had a question come in and they asked, is a disclaimer required now or later this year? When did it go into effect?
So August 28th. So the majority of the regulation, all of the regulation except for the implementation of those two items, that marketing pamphlet and the standard disclosure, went into effect May 28th. So those kinds of disclosures, as far as what should be in a contract and what should be in the items that the marketer is giving to them outside of the standard items, was May 28th. And then the documents for that we created under the regulation, the marketing pamphlet, the standard disclosure, that was August 28th. And I'm going to kind of supplement that a little bit too with folks. I think some folks that we have spoken to were concerned that we were going to come out guns a-blazing, start writing everybody up for everything. But as I mentioned earlier, we're trying to educate. We're looking for good faith efforts from folks from trying to get these things implemented. But also, I would encourage you, if you have questions about it, don't just stand out there with your ostrich head in the sand on things. You got to reach out to us, ask us the questions. We'll be happy to answer and guide you along to the best of our abilities for these things.
Any other questions we may have? All right, on that note, I'm gonna go ahead and end this webinar. Thank you so much, Carrie and Gretchen, for being on the line. This has been great information. I'm excited to get things posted. I'll get with y'all about what you're gonna allow. And I know everybody has different rules about whether PowerPoint can go up or live video. We have been recording this if we can post it, but I'll get up with y'all offline about all of that. But thank you everyone who attended. We have a great crowd here. I'm excited to get the word out and to help facilitate get pushing this information. And we hope to see you all in October.
Thanks for having us.
Thank you, Connie.
all.